My name is Johann Hattingh. I am the chief editor of IBFD's Bulletin for International Taxation. The journal is celebrating its 75th anniversary this year, having been founded in 1946. And this November, a special issue will be published on the theme of 75 years of international taxation, looking back and looking ahead. Today, I welcome with me one of the authors to our special issue of the Bulletin, Professor Stef van Weeghel, who wrote a wonderful article on the topic of have the OECD and UN models served their purpose, and are they still fit for purpose? Welcome, Stef.
Good morning, Johan. Thank you.
So Stef is a professor of international taxation at the University of Amsterdam and global policy tax leader at PwC. And also chair of the board of trustees at IBFD. So it's a particular pleasure to have him with us today. Stef, I'm going to start by asking you what attracted you to this topic and why did you write on it?
Well, the first part of the answer is easy, Johan. The authors were given a raft of possible topics, so I limited my choice to the list. But I was intrigued by this one, to look at the OECD Model Convention and the UN Model Convention, to look back to the history of those conventions, the development, and then think a bit about what the future has in stock for us. And it also forced me to step back. I think we as tax practitioners and academics have an inclination to stick to technical themes. We like that. It's very comfortable to talk about residence or permanent establishment, but to step back and ask the question, what is really the meaning of these models? What have we achieved? That I found very interesting, and the research and the writing was a true pleasure. So I enjoyed doing that.
Wonderful. Yes, your article, if I may say so, reads as a wonderful essay. So it's not a technical piece, but a reflective piece. And I really can commend it for that reason. Let's start with the past. Have the models respectively served their purpose? What do you think are the main achievements of each of the models?
Let me start by saying that I think the achievements of both models are enormous. And it's very instructive to go back to the early League of Nations reports, because they show the debate, the discussions, the considerations. In fact, it's very interesting that some of these reports in the type of discussion are not very different from the discussion that is being had today at the level of the OECD and the inclusive framework, including the position of source countries, residence countries, separate enterprise approach versus formulary approach. It's fascinating. About a year ago, slightly more, a year and a half ago, just before the COVID lockdown, I did the traveling lectureship for IFA in Canada. I looked thoroughly at the discussions in the 30s and also the Mitchell v. Carroll report on the allocation of taxation rights. And I thought that some of the language of those reports, if you would copy, paste it into, say, a blueprint that was issued about a year ago, you would not notice because the nature of the discussion is very similar. Back to the point in your question, what has been the major achievement or have been the major achievements? It's that, first of all, countries were forced to think about the international architecture. They came to agreement, and through the OECD and the UN Model Conventions, I think we have achieved remarkable uniformity and consistency in the world, not only between the countries that have bilateral tax treaties in force, but also the notions, residence, permanent establishment, other notions have made it into the architecture of domestic law. So I think we have a good degree of organization in the international system. Of course, the OECD, as the Economist always describes it, is a club of mostly rich countries. And if you go back all the way to the London model draft, you can see, and that's been a complaint, I guess, by developing nations, you can see that there is a focus on the position of residence countries as opposed to the source countries. And I think the achievement of the UN Model Convention is that effectively that Model Convention gave a voice, and I think also a better negotiating position to developing countries. So if you look in the course of about almost a century now, the development of these models, their use in bilateral treaty negotiations and the resulting treaties, that's been an enormous achievement. If we talk about these model conventions, we're inclined to think about the instruments only, the legal instruments. But I think the OECD in particular has moved from being the sort of the organization that is the guardian of the model treaty to a standard setter. Richard Van wrote about this in I think in the book published by IBFD, the ITG special issue, and he said, you know, he emphasized how the OECD has become the standard setter of international tax norms, and I think that's an accomplishment in and of itself. It's a place where countries convene and try to overcome their differences. There are shortcomings as well, but I guess we'll get to that later in the interview. Let me stop here, Johann.
Thank you, Stef. Yes, I mean, it is almost as if you say that it's given us a common language, a common vocabulary to think about international tax and the harmonization of countries' own systems. So if we then move on to the future and the question you ask, are they still fit for purpose? You have several perspectives on this question, and the first is from practice. So I wanted to ask you, you seem to be skeptical about whether the models are still fit for purpose. And can you perhaps explain your view?
Yes, Johann, it's a difficult question. I think there are two aspects to this. One is the practical side, the application of the treaties, and the other is the policy side, legitimacy side. So I'll first address the practical side. So today we have tax treaties mostly based on either the OECD Model Convention or the UN, or a mix of both, with country-specific deviations depending on the particular country's tax treaty policy. Then we have, as an overlay to the bilateral tax treaties, the MLI. And then, as a result of the agreement on Pillar 1 and Pillar 2, we will have a multilateral convention, certainly on Pillar 1 as another overlay. Question whether we will see a multilateral convention on Pillar 2. That's not strictly necessary. I think someone at the OECD would say, of course, there are academics who have doubts and believe that existing bilateral conventions would probably prevent elements of Pillar 2. And certainly, by the way, the subject to tax rule in Pillar 2, of course, would need a wholesale review of treaties. My point here is, if you have these bilateral conventions, and then the MLI is overlay, and then another, let me say, Pillar 1 multilateral convention, and then another Pillar 2 multilateral convention, commentaries to each of these, I think applying tax treaties will become much more difficult going forward. How will the commentaries on these treaties develop as separate pieces attached to separate instruments, to a model, to MLI1, to MLI2, MLI3, what have you. So I think that that will be a practical challenge, not an impossibility, but a challenge. The second aspect that I mentioned is policy legitimacy. If we look at the world today, the tax policy, tax treaty policy, also the digitalization project is driven by the OECD. Of course, the OECD today is not just the OECD, it's the OECD and inclusive framework. But the question to me still is how the inclusiveness of the group, the inclusive framework, translates into true representation of the interests of developing countries. One could see that the dynamics in the process are still such that it's a relatively small group of countries that has enormous influence in the process. You can also see the staged approach of agreement regarding pillars 1 and 2, G7, G20, OECD inclusive framework. It starts with, and then also in the CFA, the Committee on Fiscal Affairs at the OECD, you have the steering group. So it's conceivable, not just conceivable, I think it's the reality that a relatively small group of countries drives the direction of tax policy and treaty policy. And the question is whether there should not be more participation, either on an individual or on a regional basis, by developing countries. So and of course the UN Model Convention to an extent caters for the developing countries, but I think there is room for development. I have some thoughts, but perhaps that would be in your next question.
Yes.
So I'll stop here. Yes.
Before I go on to what could be done to improve the situation, I wanted to ask you, prompt you a bit on investment and tax treaties. If it's the case that most tax treaties today are concluded outside of the OECD countries, so a lot of developing countries conclude tax treaties, of course, it comes at the background of seeking foreign investment and so on. How do you see that dynamic impacting on the future of the models?
I find it an incredibly difficult question, Johan. I think at the end of the day, it's a question of not so much legal issues or treaty issues. It's a trade-off. Where is the optimum? It's clear that certain countries benefit from tax concessions in order to attract foreign direct investment. But the paradox is that in a number of countries, the foreign investment in fact results in the largest tax revenue. So if you give up tax revenue to attract more foreign investment, but it doesn't bring you, I mean, it effectively enough revenue. I mean, I think there is a proper balance to be had between attracting foreign investment and tax revenue. And that, of course, is not just a tax question, it's a much broader economic question, and also deals with employment, industrial, economical activity in a country. So it's the whole package. And then I guess every economy or many economies have different profiles. So how that translates then into tax treaty provisions and reduction of source taxation or not is very much dependent on the overall view and the conclusions on the trade-offs.
Yes, you touched in your article on the whole investment protection treaty networked out there, and how that is not really aligned to the positions in the model. Do you think that there's scope there to do something about this situation?
There you touch on an interesting point. I guess for many decades, there has been relatively little interaction between investment treaties and tax treaties. I mean, tax treaties, as we know them, say nothing about investment treaties. There is no reference to investment treaties. Quite a number of investment treaties do refer to tax treaties or to taxation measures. So not specifically tax treaties, but they say that these investment treaties that protect investors do not apply to quote unquote taxation measures, with an exception often for expropriation. But if you look at the standards embedded in these investment treaties, so the standard would be national treatment for the foreign investor, most favored nation treatment, fair and equitable treatment, and protection against undue expropriation. These are very far-reaching provisions, and if you think of tax measures in numerous countries in the world, it's easy to see that either the measures themselves or the way in which they are executed, the tax administration, they would violate the national treatment clause or legitimate expectations as embedded in the fair and equitable treatment clause. So the potential power of these investment treaties in the regarding taxation is very significant, but it's fair to say that many countries that have concluded these treaties never thought about it. So some of them have been surprised in the past decades that the investment treaties have been the avenue for investors to launch tax-related claims with international tribunals, and some of these tribunals have awarded the claimant with very significant damages. And the recent cases in India, Cairn, Vodafone, but also in the more remote past, Yukos in Russia, prove that this can be significant. The UN has been quite active on exploring this and has been advocating to ascertain that there is more alignment between investment treaties and tax treaties, and also investment treaties and the awareness of the potential regarding taxation measures, even in the absence of investment treaties. The reason why developing countries have been reluctant to agree on mandatory arbitration, mandatory binding arbitration in tax treaties as well, because of the complexity and the significant costs resulting from the investment treaty arbitration. So that has acted as a bit of a deterrent to adoption of arbitration in tax treaties.
Thank you, Stef. That's really, I think, critical to understand the practical interaction, because there is, as you say, almost a policy gap as far as the models are concerned about investment and the investment protection regime. I think onto the future, and you've got very clear ideas about what may be done to improve the prospects of the models for the future. So I wanted to ask if you could share those with us.
What I proposed actually is to get to a multilateral convention. So if you think of the complexity I just mentioned, the bilateral conventions with the different overlays, my question is, why don't we step back and think from scratch about a new architecture in terms of the treaty network? And what I thought was, let's think of one multilateral convention that incorporates what I will call baseline provisions, residence, certain other definitions, exchange of information, non-discrimination, dispute resolution, etc. And let's have those provisions as a standard, mandatory in that multilateral convention, but then also have a menu of distributive rules that are optional. So it could be, say, different variations of the permanent establishment, etc., etc. It could be different withholding tax rules with respect to dividends, interest, royalties, what have you. A menu of options. The advantage would be that, first of all, there would be much more uniformity. I think Philip Baker wrote an article for the Jubilee issue as well on multilateral conventions, and I think he saw potential for more uniform interpretation of a multilateral convention, recognizing that it's still domestic courts that would do the interpretation. So I think there is more, I agree with Philip, there is more potential for a common interpretation. And for developing countries, there would be huge benefit, because if they sign on, they are part of the treaty club, as Cilly Dagan, I think, would call it in her book on tax policy. But they don't pay the price of necessarily foregoing withholding tax, because they can then choose from the menu of options. So I would see benefit in a multilateral convention. Of course, I'm not the first to advocate that. I think there are many before me, including Philip Baker and John F. Jones, I think, make the case a number of years ago. I think Martin Broekhuizen of the university who did his PhD in Leiden on multilateral conventions. The other thing I propose is, next to this multilateral convention, by the way, I also advocate that multilateral convention is then developed by a platform that is a true reflection of the different countries in the world. That could be the OECD Inclusive Framework, could be the platform on collaboration, could be the UN. But then to guard the uniform interpretation of these clauses, I propose that we organize a body not dissimilar to the Institute of the Advocate General before the European Court of Justice, or the Court of Justice of the European Union, and have a body of experts that are appointed, and that would, each time there is a treaty interpretation issue to be dealt with by a domestic court, that body, that institute would be consulted. So you would get on the particular issue an opinion from the Advocate General. And of course, as is the case with domestic courts and the Court of Justice of the European Union, the opinion would not be binding, but certainly would help the courts to develop their thinking and would certainly drive to more uniformity. And that would probably cater for the constitutional, practical, and political difficulties for creating one international tax court, which probably would be the ideal situation, but very difficult to achieve. So in short, a multilateral convention and a body that would help us secure uniform interpretation. Johan, that would be. I conclude my article by saying this sounds like utopia, but I reiterate, if we look where we are today, even with the existing treaty architecture we have, who would have thought a century ago that we would be today where we are today? And also, I think the discussions that have been going on in the context of the digitalization project at the OECD, whether you like the conclusion or not, proves that international discussion, participation by a sufficient number of states could lead to major achievements.
Professor Stef van Weeghel, thank you very much. Thoughts inspire, and you have illustrated how combining policy and practice can really bring a meaningful proposal, and I do hope others will take it on board. Thank you very much for this interview, Stef.
Thank you very much, Johan.